I request speakers to switch on their camera. Good evening. I am Darshita Sethia, Associate at Hammurabi and Solomon Partners, New Delhi, India. And it is my pleasure to extend a warm welcome to our esteemed speakers and valued viewers for joining us today for the insightful discussion on the two of the world's rapidly emerging markets, Panama and India. Today's session promises to be both engaging and informative as we delve into the key discussions that will shed light on the broader theme of regulatory aspects of doing business in India and Panama, a guide for entities with special focus on special economic zones and labor laws. Today's session showcases esteemed specialists who offer an extensive expertise on the crucial elements influencing the business expansion and achievement within the region. They will also share important insights regarding regulatory advancements. Allow me to introduce our esteemed speakers. We have with us Mr. Alexis V. Herrera Jr., partner at Icaza, Gonzalez, Ruiz and Aleman. Hello, sir. We welcome you. We also have Mr. Rahul Jain, partner at Hammurabi and Solomon Partners. Good evening, sir.
Good evening.
Then we have Mr. Abhishek Praharaj, Principal Associate at Hammurabi and Solomon Partners. Good evening, sir.
Hi,
And
everyone.
lastly, we have Ms. Karen V. Tejeira, Associate at Icaza, Gonzalez, Ruiz, and Aleman. Good evening, ma'am. Good morning. Before we proceed with the session, kindly allow me a few minutes to introduce our firm, Hammurabi and Solomon Partners. Hammurabi and Solomon Partners is a leading full-service law firm established in 2001. Over the years, Hammurabi and Solomon Partners has built a reputation for providing comprehensive legal services across a wide spectrum of practice areas. Our core areas of expertise include litigation, arbitration, insolvency, white-collar crimes, advisory, mergers, public policy, data protection, and real estate. We take pride in our team of 100 professionals with 16 experienced partners who bring a diverse legal expertise to the table. Our team operates across multiple regions in India, including Delhi, Mumbai, Jharkhand, and Ahmedabad, offered tailored solutions to meet unique needs of our clients. With a commitment to excellence and a focus on client success, Hammurabi and Solomon Partners strives to be at the forefront of legal innovation and provide high quality legal counsel and representation in the complex legal matters. Without further ado, and next, I take this opportunity to invite Mr. Alexis to kindly introduce his firm.
You go to the first slide, please.
Yes.
Well, to start, Icaza Gonzalez Ruiz and Aleman was founded in 1920. It is a law firm that from the start has had an international projection. Most of our clients are multinational companies that come to do business in Panama. But of course, currently we're an international law firm and we've been doing that for decades. So we have a lot of clients that from all over the world. And let me show you in the slide that the different offices that we have. So in that slide, you can see all the areas that we cover, all the practice areas that we cover, and we cover all of them except for criminal law. But in the case of intellectual property, we also provide criminal law services. We have two subsidiaries in Panama, Icaza Trust Corporation, that provides all type of trustee-related services, and then Icaza Accounting Services. The next slide, please. So along the years, we have been able to establish offices in other countries, as you can see. We have offices, our main office in Panama. We have an office in Cyprus. We have another office in Geneva, in Montevideo, and in Singapore. Those would be, let's say, the offices in large cities, but we have offices in other countries like British Virgin Island. Thank you.
Thank you, sir, for the introduction. Before we move ahead, let's take a moment to reflect on the rich historical and evolving bilateral ties between India and Panama, shaped by strategic geographical positioning and shared commercial interest. Panama and India have a rich history of trade relations with bilateral engagements dated back late 19th and early 20th centuries, where Indians played a significant role in the construction of Panama Canal, a transformative project that has revolutionized global trade. In the recent decades, economic cooperation has expanded steadily because two countries, with India's export to Panama in machinery, automobiles, textiles, and pharmaceuticals, whereas the India's Panama's key export to India are iron, steel, copper ore, and wood. Nonetheless, the shipping industry remain a cornerstone of our trade practices. Now, moving ahead with the key topic of regulatory aspects of doing business in India. It is essential for foreign investors and businesses to understand the legal and regulatory framework in place. One of the most significant aspects of doing business in India is special economic zones, which are designated areas of offering favorable conditions for businesses, including tax exemption, regulatory relaxations, and infrastructure support. Now I invite Mr. Rahul Jain, partner at Hammurabi and Solomon Partners, to share his insight and guide our viewers in understanding the framework, benefits, and key consideration of special economic zones in the context of doing business in India, and what opportunities do SEZs in India present for Panamanian investors, and how they can navigate the associated compliance framework effectively. To you too, sir.
Thank you, Darshita. Hello, everybody. This is Rahul Jain from Hammurabi and Solomon Partners. I take care of the Bangalore office. I am located at Bangalore, and welcome to Team Panama as well. Good evening, good morning to all our viewers. India is at the juncture of creating a very fast economic you know country wherein it has done a lot of developments in its ecosystem prima facie with respect to post COVID and before COVID. uh, Post the political regime got changed. So primarily, if you see, it is the fastest growing economy in the world. It is having a manpower in terms of 1.4 billion as a population. Globally, estate investments, it is ranked as number three. In the ease of doing business, because of so many changes happened in past decade or say 15 years, India has ranked as 63 in the ease of doing business. In terms of FDI, foreign direct investment flow, with respect to 28 USD, it is ranked 15th, and it is emerging as the largest manufacturing hub by 2030. As we know that it's a plus one option for other countries across the globe post COVID. Uh, it is having a connectivity in terms of uh, INSTC connectivity from India to Russia via Iran, and also through Middle East region via IMEC. Next slide, please, Darshita. So if you see, with respect to investments, India has two investment routes. One is with respect to regular areas wherein you have a automatic approval route wherein you can do your investment, and then you need to notify Reserve Bank of India, which is the apex banking authority in India. So these routes are automatic approval routes wherein 100% of FDI is allowed. These routes are automobiles, manufacturing, agriculture. In terms of automatic route approval, you also need to have a wholly owned subsidiary which can be controlled by a foreign entity, and the operation and control can be taken care of by the foreign entity, and that particular entity has to be situated in India. So we will also talk about that, what kind of business structure it needs to have, so that you can take care of that particular wholly owned subsidiary from India. Other strategic investment, just hold on, Darshita, we on the same slide. So yeah, other strategic investment method is are there with respect to routes which are not prohibited but regulated. You need to take government approval, uh, and additional approvals may also required if it is with respect to defense or aviation or media and telecommunication industries, because India has identified that some sensitive countries are there from where the investment comes. They need to have a additional regulatory conditions to be fulfilled, and the government permissions are required. So in terms of investments, we have a venture capital which can invest in India in terms of startups, and of course through foreign institutional investors and foreign portfolio investment. Next slide, Dashita. So these are the major sectors in which India is going forward in a very, very robust manner. And of course, as my personal experience, I've worked in e-commerce domain. So if you talk about technology, if you talk about the ecosystem of artificial intelligence and all, every area is being transformed in terms of digital transformation, and now in terms of artificial intelligence and other transformations are happening. So the major areas in which we can invest is edtech, tourism and hospitality, fintech, financial technology, manufacturing and FMCG, electric vehicles, health and innovations, and of course information technology, wherein India is taking care of huge investments, foreign direct investments in terms of artificial intelligence, data privacy, as new data protection law is in framework is in going on, which the recently rules have been notified. The process of notification is in the process because the consultation, public consultation, is going on. Next slide, please, Darshita. So, if we talk about the regulatory advantages to invest in India, so we have a production-linked incentive scheme. So there are 14 sectors which have been opened by government, wherein they are looking for a total outlay of 1.97 lakh crore of investment from these sectors. Um, uh, I've been part of this company Samsung, wherein we have filed this particular application, and we have created the biggest manufacturing unit of Asia at that point of time. Um, so this scheme is primarily, putting manufacturing output of 40 lakh crore. So production link incentive scheme is primarily, giving more incentives if you are having incremental sales over base year, and domestic manufacturing are being attracted by the foreign investors in this particular scheme. So this is highly beneficial scheme wherein if you come to India and you want to do production in India, you will get all the concessions under the scheme. Then India have a very specific, zones which are made as a export zones. These are known as SEZ, Special Economic Zones, wherein you can get various kind of exemptions while doing business from such zones. These zones have to be, the exemption renewal has to be done every 5 years, and you can do you can get exemptions in terms of custom duties, in terms of operational cost, in terms of businesses in this particular zone. So primarily, when you want to do business from these particular zones, there is a process within which you can get approvals in a very faster time frame, and you can set up your business in these zones in a very uh, a regulated and faster manner with all the approvals in place. So, two very good examples of special economic zones are Ennore Special Economic Zone in Chennai and Gift City in Gujarat. So, these are same kind of zones like we have Delaware in US, or we have Hong Kong and Singapore, wherein you are getting a lot of perks in setting up of business in these zones, so that you can do business in India in a very regulated, faster manner and get all the concessions. Next slide, please. So moving forward, total number of special economic zones, we have 218 numbers. Um, the couple of numbers we have in terms of how the journey of special economic zones. So first special economic zone have been opened in 1965 in Gujarat in India. But after that, because of probably how the development took place, the next special economic zone charter started in 2000 only, and then it has leapfrogged in its development, wherein in 2005 and 6 we have a special economic zone statutory law in place, and you are able to do operations in these units. So if you see 20 years from 2005-6, we have done massive improvement in terms of investments in special economic zones, operations of special economic zones, and the exports from special economic zones, as per the number displayed on the slide. With respect to special economic zone, as I've already told, we have law in place. In 2005 the act came into picture. In 2006 the rules are there in picture. So there is a process with which you need to go in the approval process. You need to file your application with the development commissioner, and who overall in overall take the administrative charge of special economic zone, and then your application move for the registration of your entity in special economic zone. So there is a mechanism as well, which is also known as Jan Sunwai under special economic zone, wherein you can get your grievance addressed under the scheme. Next slide. So this is the typical slide we have created, wherein we identify how to set up a business in special economic zone. So you need to identify the location. Um, Hammurabi and Solomon Partners can advise in terms of how the particular special economic zone is useful for you in terms of availability of resources, labor, skilled labor, and in terms of other raw materials available under the infrastructure. Step two is how you need to get the provisional approvals, and then you need to submit that application with the development commissioner under step 3, and then your application, probably if there are some discrepancies, you are getting an opportunity of being heard, and then with letter of approval you get your approval under the Special Economic Zone Act 2005, where you can set up your business, and you need to enter into a lease agreement with the developer of the special economic zone to initiate your working and operations. Next slide. So again, special economic zones are special areas. It has given special treatment in terms of compliances. So, of course, you need to take care of your responsibilities as well if you are working under special economic zone. So, positive not net foreign exchange earning requirements are there, because you need to have your exports and imports in control, so that you need to have positive net foreign exchange. You need to sign a bond come legal undertaking in Form H with the development commissioner, so that you will get exemption on the custom duties. You need to have certain approvals, which are CTO and CTE under the environmental pollution control norms, because environment is a major thing in India, wherein you cannot run away from such approvals. And then you need to maintain. So there are a couple of compliances under the company law of India as well. So you need to make submit the audited balance sheet of last 3 years and income tax returns, and you need to share letter of approval before expiry of 5 years. So that has to be renewed every 5 years. Next slide, please. So, we understand how the hybrid workplaces worked in COVID. So, a couple of exemptions are there in terms of if somebody wants to work outside of special economic zone, then it is required, work from home category. And of course, whatever stationary items you are using for working for special economic zone, that can also be exempted for any kind of duties, because if you can take it out of the special economic zone while working from your home. So those are a couple of labor exemptions we have. Um, so with respect to regulatory advantages to invest in India, foreign direct investment and tax reforms are the key reforms which need to be taken care of. So we are having 100% foreign direct investment policy, wherein under automatic route, without any government approval you can do investment, which I've already told. And there are a couple of prohibited areas like e-commerce, information technology, and telecommunication, where you need to have some sort of approval required. So I worked for one company, Walmart, Flipkart, wherein for B2B segment there are certain approvals required, and you cannot do direct investment in those entities, although in B2C you can do direct investments. uh, then of course, FEMA compliances with respect to foreign exchange have to be taken care of under the Companies Act and under the FEMA laws. And of course, we have a single window platform in terms of foreign investment facilitation portal, wherein you can go with all your documents and get FDI approval requirement in one window. So that is a platform which is very, very easy, and allowing you to get approvals. If you see tax reforms, so a couple of rates have been identified as a corporate rate: 22% for domestic companies and 15% for new manufacturing firms, which has been reduced corporate taxes of the regular firms. 100% tax holidays are there for the first 5 years, and of course, it is going for 50% in next 5 years, and another percentage are available for next 5 years. So around 15 years of tax holidays are available in tax reforms. And so in India in 2016 we have created a single regime, goods and services tax. Before that, we have direct tax, indirect tax, service tax. A lot of taxes are there. So now GST is there, so it's a single window streamlined tax system which replaces all the central and state taxes, and the one structure has been put in place which operates across India. Of course, CSR, corporate social responsibilities exemptions are also available, which is basically 2% of your net profit or turnover or net you know returns needs to be calculated from. So that has been exempted for special economic zones. Again, so a lot of free trade agreements are there, wherein uh, the business can be done without any duties. Of course, we understand that a lot of them are there. With respect to foreign investors to source raw materials and intermediate products at lower cost. So a couple of exemptions are there available with respect to free trade zone. These are the Government of India initiatives, and of course we have a Startup India scheme. So for startups in India, we have created a startup fund of around 10,000 crore. It's a dedicated fund for startups. And if you are able to come over the threshold of certain turnover and certain time period, and you are creating some solution with respect to enhancement of wealth creation and creating employment, then you will be eligible for such startups India scheme. Next slide. Um, again, so these are a couple of more initiatives by Government of India. So Nidhi scheme is there, Startup Investor Connect is there, a remission of duties and tax on imported scheme, exported product scheme is there, Atal Innovation Mission is there. So basically, this is it's an incubation center mission which helps health tech or fintech or ed tech startups, and it created a ecosystem wherein from incubation of your idea till the exit, you will be getting all the support from the government. Even in the filing of patent and trademark applications, you're getting concessions, and these are being filed by the IP facilitators, wherein the entire professional fee has been given a rebate of. Next slide, please. Next slide. Yeah. So again, with respect to ease of doing business and labor law reforms, I think so. Of course, if you see that incorporation fee has been removed with respect to if the company is having authorized capital of 15 million INR, and they are having improved uh, digitized trade processes. And then, of course, there is a national single window system to streamline the approval processes, which I've already told, which have been covered in the earlier slide. And of course, on labor reforms, I put this in front of Abhishek to take forward from here.
Thank you, sir, for this insightful and detailed structure of CES in India. Now, interestingly, this year has marked the first ministerial level visit, which has played a significant role in strengthening the bilateral ties, fostering collaborations on projects aimed at enhancing both physical and social infrastructure between Panama and India. So, with this background, now I would like to invite Mr. Alexis to kindly guide our viewers on what incentives and initiatives or regulatory benefits does Panama offer to foreign investors, similarly to what has been explained in India. Over to you, sir.
Hello again. First of all, let me give you some background about Panama with respect, or perhaps some of you don't know. Panama is a small country in Central America, and its independence was in 1903. So we are a very young country, but from a historical perspective, we were very important. From Panama, all the expeditions by the Spaniards to conquer South America, they all started from Panama. So Panama had its own channel, with respect to transportation way before the Panama Canal. There was transportation from Panama to and from the Pacific to the Atlantic, and the Atlantic to the Pacific. We are a dollarized economy. Our currency has always been the US dollar. We have a local currency called the Balboa, but it's equivalent. Its value is equivalent to the dollar, and that has been from the start of the country. We do not have any foreign exchange restrictions whatsoever. It's probably the easiest country in Latin America to do business if you were a foreign investor. So, we don't have any restriction with respect to foreign investment, except for owning land close to the borders or islands within the country. Our Hindu business community has always been very strong and still remains very strong. With Panama, it's a very nice melting pot. This is where all the different religions and different culture and background and races get together, and that's the way our society, our Panamanian society has always been. With respect to establishing companies in Panama, or to do business in Panama, you have two choices. You can either incorporate a Panamanian company, which is a very, very flexible entity, and it can be formed within 1 week. Or you can register a branch of a foreign company to do business in Panama. Of course, from a limited liability perspective, it makes more sense to register or incorporate, a Panamanian company to do business. Now, talking about our regime of special economic zones or free zone, let's go to the next slide. So it really depends on the activity that you want to do. I'm not going to talk to you I'm not going to talk to you in detail what you have to do in order to establish yourself under any of these regimes, but just letting you know, being the second oldest and top three firm from a size perspective in Panama, we have plenty of experience assisting our clients in establishing themselves or taking advantage of the different regimes that our legislation provides. It all depends on what you want to do and what type of business you are. For example, we have the City of Knowledge, which is a specific area within the city, and that relates to higher education, research and development, software and hardware development activities, etc., etc. The Panama Pacifico area, it's an area which is just across from the canal. You just cross the canal from Panama City, and within 10, 15 minutes, you're there. And from there, you can engage in different type of activities like logistics, shipping, aviation, call center, back office services, with a very, very advantageous regime from a labor and a tax and customs perspective. The Baru Free Zone it's an import-export zone close to Costa Rica, so that's far from Panama City. The Colon Free Zone, which was our first free zone, the oldest free zone in Panama, it's in Colon, but Panama being a very small country, you can cross from the Atlantic to the Pacific within less than 2 hours. So, within less than 2 hours, you will be in Colon. And Colon, being Panama in the Pacific, Colon is in the Atlantic side of the Panama Canal. And from there, you can engage in import-export and related activities. You have the fuel or fuel-free zones. They used to be called petroleum-free zones, but the law was changed in order to include more environmental friendly matters or products. So therefore today it is called petroleum free zone, and they're really established in order to the main activity is to store petroleum products without paying tax. We have the SEM regime and the EMA regime. Those are created for multinational companies, and we'll talk a little bit more about them, but the general idea is to establish a headquarter in Panama in order to provide back office and other similar services from Panama with the help of Panamanians and also foreign employees. You know, coordinate activities from a regional perspective or from a worldwide perspective, etc., etc. And then we have the agro parks, which relates to all type of activities that to maximize the value with respect to matters related to the production of agro-food products. Next slide, please. So some of those regimes will be established in specific areas, but we have a general law related to free trade zones by which you can, with the right investment and with the right assistance, you will be able to establish a free zone where you have located land or facilities from which you can operate it. So it is a very flexible regime. But I'm talking about flexibility. Let me talk a little bit more about the SEM and the EMA regime. When talking about SEM and EMA, remember that we're talking about multinational companies. Under the SEM regime, we have 186 multinational companies established in Panama. The main requirement there is that the company has to have more than 200 billion in assets, or the group, sorry, the business group has to have more equal or more than 200 billion in assets, or the other options that it must have at least seven offices worldwide. In the case of the EMA regime, it is the same thing, but the difference between the SEM and the EMA regime is that if the SEM is like a back office and an office that will be used to coordinate operations of the company internationally, the EMA regime has to do more with manufacturing and remanufacturing, maintenance, repair, R&D, logistics related activities to be done within Panama. Under both regimes, the services, of course, have to be provided to the economic group. It's not the purpose of these regimes is to provide the service to your own company group. Next slide, please. So from a tax treatment perspective, I just want to summarize the income tax, the income tax advantages that the different regimes provide. In the case of the SEM and the EMA regime, remember that the advantage of that one is that you can establish yourself anywhere. It doesn't have to be a specific economic zone or a specific location. You can be under the SEM regime anywhere. You just have to apply for it and comply with the requirements that I mentioned before. As you can see, most regimes provide a zero income tax treatment. The way it works, why does it work that way? Because Panama has a territorial tax system. So therefore, in the case of the income that is not considered income from local sources, from Panamanian sources, the tax is zero. It doesn't matter if you're in a free zone or not. For example, if you establish if you establish a local operation, but from that office, you are coordinating the sale of goods outside of Panama, you don't have to pay income tax with respect to that portion of your operation. But in the case of the special zone regime that we're discussing today, the advantage is that you will be operating from there, you will be having employees from there, but you don't have to pay any taxes in most of them. In the case of the SEM and the EMA regime, in order to comply with the OECD and the GAFI requirements, and so that you can take advantage of double taxation treaties and other advantages when you have a tax domicile or tax residence in a specific location paying taxes. That's why the law was changed a few years ago in order to establish an income tax, but it is a very low income tax rate, as you can see in 3 and 6 in the current slide. Next, please. We have in general, and just to summarize, we also have a call center regime, which is granted by the Free Trade Zone law, the General Free Trade Zone law that I mentioned before. So you can establish a call center anywhere in Panama, anywhere, similar to the SEM and the EMA regime, and you would be taking advantage of those incentives, which are labor, tax, custom incentives, as I mentioned before. And Karen will talk to you more about also the visa incentives that we have. Then we have the 5% dividend tax, which is the one that applies to all the different regimes that I mentioned, except for the SEM and the EMA that have 0. In the SEM and EMA regime, we have an excellent advantage that with respect to foreign employees, and just foreign employees, not local. The foreign employees do not have to pay any income tax or social security obligations. And to finish this portion of our presentation, our VAT, which is normally just 7%, the VAT does not have to be paid with respect to, for example, goods that you are bringing into the free zone where you're located, or goods that are exchanged between companies established in the different free zones. So with that, I thank you for your time, and we'll continue.
Thank you, sir, for telling us the interesting and less known facts about Panama, and especially the benefits which the foreign investors can gain by investing in Panama. We appreciate the knowledge shared, sir. Now, Panama has notable presence in India through Panama Group of Companies, a diversified amalgamation of entities in transportation, logistics, and trading of various products, including petroleum products. Similarly, India supports trade facilitations through key enterprises such as Shipping Corporation of India, which plays a vital role in enhancing trade connectivity and infrastructure development. With such huge enterprises come large number of laborers. Now, labor laws in any country are crucial for ensuring workers' rights and maintaining industry harmony. With recent reforms in the labor laws of India, including the introduction of new labor codes, the landscape has evolved. Our landscape has evolved to provide more streamlined and business-friendly environments. With that, I would now like to request Mr. Abhishek to guide our viewers on the labor regulations often differ significantly across jurisdiction. Could you highlight the key features of Indian labor laws, particularly concerning the foreign workers, contractual obligations, and dispute resolutions? Over to you, sir.
Sure, Darshita. Thank you for your question. Hi, everyone. So, as Mr. Rahul Jain was stating some time back, India is indeed an attractive destination for foreign investors and people who seek to do business here. due to the overall low production costs and the general affordability of labor. So Darshita, in order to answer your question better, first we need to understand what are the main sources of labor and employment law in India and how it is made applicable to employees, as in how it is implemented upon employees working here. See, India follows a federal form of governance, and the applicable employment laws are a combination of various central and state laws. Darshita, if you can quickly point to the slide where all the major labor acts in the country are highlighted. So viewers, the central laws regulate things like the payment of minimum wages and the employee benefits, such as provident fund, gratuity and bonus, retrenchment and layoffs, hiring of contract labor, among other things. These states, on the other hand, are free to expand upon as per their needs or amend the provision of the central laws or enact other state-specific laws or rules for the protection of employees. For instance, each state and union territory has a separate shops and establishments act that typically regulates the hours of work, the payment of wages, leave, holiday, terms of services, and the likes. In addition to these laws, the internal policies of organizations may regulate the employee conduct and conditions of work, which of course have to be consistent with the applicable laws and cannot contravene them. Some of these applicable laws you will see in the slide in front of you. So they govern everything from individual employee-employee relations to how trade unions are supposed to function, the social security aspect of it, the occupational safety aspect of it, the health standards that have to be maintained, and the likes. These laws that you see in front of them are presently in force, but the Indian government has proposed codification of these various employment laws under four major codes, under four major banners, which are namely the Code on Wages 2019, the Code on Social Security of 2019, the Industrial Relations Code of 2019 and the Occupational Safety, Health and Working Conditions Code of 2020, which are expected to be enforced later during this year. One interesting thing to note here is that all these labor laws regulating employment relationships in India also apply to foreign nationals employed in India without much reservation or without much demur. These include the Employees Provident Funds and Miscellaneous Provisions Act, the Industrial Disputes Act, Maternity Benefit Act, State-Specific Shops and Establishment Acts, the Provident Fund Law, which is a social security law that has been specifically enacted, to provide future social security to citizens of the country, have been specifically extended to foreign nationals employed by an Indian company also, subject to, of course, any agreement India has with the foreign nationals nation on such social security issues. These laws also, if you see, they mandate fair treatment and compensation of employees working in India, whether they are citizens or whether they are expats or they are here on a temporary visa working. The Constitution of India specifically prohibits discrimination on the grounds of religion, race, caste, etc., not just in private but also in government employment. Further, there are various other employment laws that prohibit and address discrimination related issues. For instance, the Equal Remuneration Act is an important act which mandates equal remuneration and service conditions for men and women for who are indulged in the same or similar work, and the act prohibits any form of discrimination against any member during recruitment. Apart from this, there are specific laws that prohibit discrimination against female employees. There are laws which protect women who are availing maternity benefits. The laws state that they cannot be fired if they choose to undertake maternity leave. There are laws to protect people with disabilities. There are laws to protect people, transgender persons. There are laws state that you cannot discriminate against any person on the basis of their gender or gender identity. There are laws to protect persons affected with HIV/AIDS. There are also various authorities and courts an aggrieved employee can approach with the grievances to seek the resolution. That of course depends upon the nature of the grievance and under what legislation the grievance falls under, which will help in determining which particular court, forum or authority the aggrieved employee can visit and seek redressal of their issues. For instance, under the Prevention of Sexual Harassment Act, the aggrieved employee may approach the internal committee constituted within their organization, that is within their company, to address their grievance. And under the Maternity Benefit Act, the act provides that they can approach the relevant jurisdictional court. Additionally, in cases of corporate whistleblowing employees, the Companies Act in India mandates that the employees can approach internal stakeholders as well as the police and law enforcement to get their issues resolved. The Act also mandates that there should be mechanisms through which employees can report malpractices committed by their directors and supervisors. There are also laws in India which prevent termination of employees for frivolous reasons. In fact, courts here have mandated that terminations should not be meted out to employees in bad faith, and insofar as they're applicable, employees should be afforded an opportunity of fair hearing. Other common disputes between employees and employers arise from breach of restrictive covenants by employees. The most common forms of restrictive covenants in employment contracts between which govern employee-employer relations generally include the covenants on exclusivity, non-compete clauses, non-solicitation clauses, locking period related clauses, and confidentiality clauses. So these clauses generally, when they are enforced during the existence of the employment, these covenants, unless they are completely becoming unreasonable or they are completely unconscionable, one-sided, or the employees, or the employee has an unequal bargaining power at the time of entering into these agreements, they are usually recognized by and enforced by Indian courts. On the other hand, to compare, these covenants may not be the covenants that restrain an employee from, exercising a lawful profession, trade, or business post termination of employment or post at the end of employment, such as a non-compete clause operating post-termination. Even if reasonable in nature, they are void by the virtue of Section 27 of the Indian Contract Act, which specifically prohibits agreements in restraint of trade, save for, let's say, limited cases involving goodwill or proprietary information. Confidentiality clauses, they have generally been enforced by Indian courts, even in a post-employment context. Courts in India have also upheld non-solicitation obligations subject to them being reasonable and for a limited period of time. So this more or less sums up how employer-employee relationships in India are governed. Over to you, Darshita.
Thank you, sir. Thank you so much. Before we move ahead, I would like to request our viewers that if they have any questions, then they can put that in the chat box of YouTube Live and we'll answer the questions at the end of the sessions. Now, the success of labor laws has resulted in the benefit of approx $600 million to both the nations, Panama and India, qua the financial trade of 2022 and 23 only. Currently, both jurisdictions are focusing on expanding these numbers. With that, I would like to invite Ms. Karen to guide our viewers on understanding what steps should Indian companies take to ensure the compliance of Panaman labor laws while setting up an operation or forming partnerships there. Over to you.
Well, good morning, everyone. First, I will start in saying that when company who wants to start or setting up operations here in Panama must comply with the Panamanian Labor Code, the Social Security dispositions, and in the event that the company wants to have foreigner employee, they must make sure that the foreigner employee has work permit and resident permits that allow them to work here in Panama. Okay. When hiring an employee here in Panama, the company must subscribe an employment contract. This employment contract would be for definite period or a specific work. And when the first employee is hired, the company should subscribe on the company should be registered at the Social Security Agency as an employer. In this chart, we will see the labor benefits that some of the economic zones in Panama offer to companies and employees. Okay, we have the City of Knowledge and the city of knowledge, where we can see the overtime and surcharges that it should be paid to the employees. We have to say that one of the most relevant benefits that those economic zones offer is regarding the overtime surcharges that the employee will be entitled to receive. The Panama Pacific area, the EMA area, and the SEM regimes establishes that the employees will be entitled to receive a 25% of surcharges, and regardless the period of the day that they made the overtime. For the other economic zones and for the regular company that operate here in Panama and that they are not in the economic zones, the law says that the surcharges could go from 25 to 75%, depending on the period of time which this overtime is made. The weekly rest day here in Panama is Sunday, but some economic areas like the Panama Pacific area and the EMA area allow companies to agree a different weekly rest day with no surcharges, okay? The cause on the forms of terminations of the employment relationship here in Panama are in the labor code, and it is important to mention that employees here in Panama are entitled to receive 30 days of annual leave or vacations, and it could be divided in 2 periods or less if the company agrees with the employees. Now we will see the residence permit benefit. Darshita, we can go to the next slide. Thank you. The Immigration Authority has created some special migratory categories for foreigners who wants to come and work or to reside in Panama. We have, for example, for the City of Knowledge, and they are resident permit for researcher, technician, businessman, professor, or a student. The main requirement of this residence permit is to have a letter from the City of Knowledge that certify that the person will be working or studying in this economic area. We have the Panama Pacific residence permit, and we have the residence permit within the 10% of the ordinary employees. This residence permit required the company to have 10 Panamanians employees to hire 1 foreigner under this residence permit. Also, the salary that this foreigner receive cannot exceed the 10% of the total salaries that the Panamanians employees receive. We have the 15% of the regular employee, which is pretty much the same as the 10%. The company will need to hire 10 foreigners employees in order to hire 1 foreigner employee under this residence permit. And the salary that this foreigner receive cannot exceed the 15% of the total salaries of the Panamanian employees. Under certain assumptions, the migratory office could approve a residence permit up to 15%, but it will need to verify certain circumstances. Okay, we have also the residence permit for a company who has less than 10 employees. That means that company that has 9 Panamanian employees or less could apply for this residence permit. And we have the provisional residence permit for investor of Panama Pacific area, which establishes that the foreigner should invest $250,000 in the Panama Pacific area. We have also the colon-free zone, which the foreigner can apply for temporary permit for foreigner personal hire for executive company that operate in the colon-free zone, as his name implies, and this could be for executive that work for the free zone, and as minimum salary for this foreigner should be $2,000. For this zone, also might require a certification for the Colon free zone in order to apply for this resident permit. Also, there is a resident permit called macro company investor who require a foreigner to invest $160,000, and the company must have also 5 Panamanians employee to apply for this visa. Okay, the SEMA and the EMA visa are pretty much the same, are for foreigners who work for a SEM or an EMA visa. The advantage of this type of visa for the foreigners, as Mr. Alexis mentioned, the salary that is paid to the employees will be exempt of income tax and social security obligation. For the agro park area, we don't have like a specific or a special visa, but under this regime, the company could obtain work or residence permit for their employees under the 15 or the 10% of the personal ordinary, or could also apply for the macro company investor visa that we have previously mentioned. Thank you.
Thank you, Ms. Karen. With this, we mark the end of the discussion. And before that, I would like to thank you for esteemed speakers who have shared this expert knowledge with our viewers, especially to Panama team who has agreed for this webinar at this early in the morning in their country. Thank you. Thank you so much. And I also would like to thank our viewers for their time and patience for the session. I believe currently we do not have any questions. As and when we get it, we'll post it on the YouTube channel and try to answer as many questions as we can. Thank you so much.
Thank you.
Thank you, everyone.
Thank you.
Thank you.
Have a nice day.